Welcome to Live at Lunch. This particular video is focusing on the beginning of Q3 and specific steps you can take for immigration compliance. So immigration compliance can seem daunting, especially depending on the number of employees that you have who are foreign nationals and are being sponsored in some way through the US immigration system, or even if you just have one, it can seem daunting because there's so many regulations that you have to follow. But I encourage our corporate clients to focus on one specific step at a time. Just that's all you can do, right? Is to focus on one thing at a time. So here at the beginning of Q3 are three things that you can take a look at to save time, headache, and effort down the road and to establish good habits in terms of immigration compliance. The first one is to review your list of foreign nationals who are being sponsored and see whose status is going to expire within, I would say, the next 8 months. Typically, you can extend a status within by filing, it depends on the particular immigration classification, but typically you can extend a status by filing up to 180 days in advance. So for example, if you have individuals on an H or an L, or if you have individuals who are going to file their extension here in the United States and they're here on a TN or an H-1B1, you can start those filings now and file sooner rather than later. Again, it depends on the classification, but typically up to 180 days in advance, you can file those extensions. The reason that's helpful is because you decrease the opportunity or the chance that you would need to pay for premium processing. So in other words, the sooner that you file, the longer it has to be approved before the person's status expires. For a lot of classifications, keep in mind that there's a regulation that permits the foreign national to be able to work for up to 240 days beyond the expiration of the current I-94, that is the expiration of the current petition, as long as the petition was timely filed. Again, depends on the visa classification, but know that that's there. But in general, the sooner you file, or the further advance that you file, the less chance it is that you're going to have to pay that $28.05 for premium processing. It also really helps reduce stress for the foreign national employee if they know that it's taken care of, that it's submitted, that they can work for a longer period of time without having to worry about the expiration. It also can be very helpful for foreign nationals in terms of having their driver's license extended. A lot of times their driver's license will be tied to the expiration of their current status. And it varies by state, by the DMV's requirements. Sometimes they can get it extended if they have a receipt notice. Other times they have to have the approval notice. So that can be a concern for your foreign national employees as well. And if they're not stressed about that, they're able to focus on their job. The second thing to consider doing is taking a look at your list and seeing whose status is going to end. Again, I would say within the next year. Again, as to point one, to see who it is that you need to file an extension for, but also whose status is going to expire within the next year or so, or potentially longer, that you may not be able to extend after that. So for example, and again, it really varies by classification, but for example, if you have a foreign national employee on H-1B status, a person can hold H-1B status for a total of 6 years. That does not count time spent outside of the United States, but that total is 6 years. It is possible to extend the H-1B status beyond the 6th year if the foreign national employee is at a certain point in their green card process. Namely, that is, if they have filed or if you as the employer have filed the labor certification at least 365 days before the end of the 6th year, or if you have filed or the employee has an I-140 petition that is approved, they can extend in 3-year increments. Whereas with the first one, if you file at least 365 days before the end of the 6th year, they can file in 1-year increments. So really, you need to be looking at that. I encourage employers to look at that, and we remind employers to look at that really from the first time that the person joins the company in H-1B status. Look at how much time they have left and make a plan as to when you're going to start the green card process, or if you're going to start the green card process, because you do not want to be in a situation where the foreign national employee is in the 5th year or maybe even the 4th year and there's not a plan in place and they're not going to be able to extend their H-1B status in a timely manner. And then there's an interruption in work authorization it's really stressful for everyone involved. So definitely for H's, you want to take a look at that from the very moment that they begin really working for the company in H-1B status. Other classifications you cannot extend beyond that time frame, even if they have a green card in process. So for example, L, there's a limit of 5 years for L1B and a limit of 7 years for L1A. So in those situations, you want to be having a conversation with your immigration lawyer about what are we going to do? Is this person going to go back home? Are we going to sponsor them for a green card? If so, are they likely to be able to get the green card before their current L expires? Do we need to look at changing them to a different visa classification? A lot of times I've had clients change from from L to H so that they're able to extend the H-1B status. Remember, the time spent in L counts against the H limit and vice versa, but sometimes there's a strategic move that can be done there to allow the person to continue working in the United States indefinitely. So you want to be looking at that as well. Other visa classifications don't necessarily have limits as to the number of years that they can be in the United States, at least nothing that's written in black and white. But for example, you can't hold TN status for 50 years. At some point, somebody is going to say, whether it's the officer at the port of entry or USCIS is going to say, this actually does not look like a temporary position because the person has been here for 50 years. That's an extreme example, of course. But think about long term. Are you going to continue to hire that person? If so, for how long? And you need to think about other options, whether it's sponsoring the person for a green card or changing them to a different visa classification that would allow them to stay for a longer period of time. And that's not limited to TN. That can apply to H1B1, to E3, to E2, any number of other classifications. But it's something to keep in mind and to be really intentional about and strategic about from the moment that you hire that person. And things may change over time. You may not know when you hire a person, of course, how long you're going to employ them, or if you need to think about the green card process, but it's something to have in the back of your mind and a conversation to have continuously with your immigration lawyer. The third thing to take a look at is record retention. There are a lot of records that you need to keep in terms of US immigration, including I-9 documentation, public access files, if you hire individuals who require a labor condition application, which would be H-1B, H-1B1, E3, things like that. Anyway, there's a lot of document retention rules to consider, but I'm encouraging you to focus just on one thing right now. Of course, you have to adhere to all of the, you have to fully comply with all of the regulations, which is a lot. But right now, think about what do I need to take a look at to make sure that we are doing what we need to do, and then set up systems so that we can ensure compliance in the future. So right now, think about your public access files. Again, if you hire foreign nationals who are on H1B1, E3, those all require an LCA, labor condition application, and those in turn require a public access file. So there's certain documentation that you have to keep on file for these particular individuals. So make sure that you have those, that you have the public access files. Make sure that information is being updated. So for example, if there are wage changes, you do have to update information in that public access file. And make sure that you are retaining the documentation for as long as you need to. Specifically for the public access file, you have to keep the public access file for at least 1 year beyond the last date that that particular foreign national is employed under that H-1B, or for the duration of the labor condition application, the LCA, whichever one is longer. So you want to take a look at those and see if there are any that you need to keep, or if there's others that you can potentially not keep based on the duration that's required. So those are 3 things. Again, you have to comply with everything. So as you're filing immigration paperwork, or as your company is doing that, you want to make sure that you understand the requirements and what you have to do to comply. But it's also, you also have the responsibility of making sure that you have ongoing compliance. And it could be that maybe you're new to the position, or the position has changed over time. So it is a healthy and good idea to take a look very intentionally and periodically at your immigration compliance. I hope that you have found this helpful. If you have, please share it with a friend. Otherwise, I will see you next week for Live at Lunch at noon. I am Emily Sumner with Sumner Immigration Law, serving clients from around the United States and around the world with employment-based and family-based immigration matters. Until next time.